There are 6 major requirements that must be satisfied before courts will treat a transaction as a legally enforceable contract. There must be an agreement composed of an offer and an acceptance upon which to base the contract. The terms of the offer must be definite and accepted without change by the party to whom it was intended to be offered. The agreement must not be based on one party deceiving another on an important mistake or on the use of unfair pressure exerted to obtain the offer or acceptance. What the parties agree to must be legal. An agreement to commit a crime or tort cannot be a legally enforceable contract. What the promisor demands and generally must receive in order to make his or her promise legally enforceable against him or her is termed consideration. To have a completely enforceable agreement, the parties must have the legal ability to contract for themselves. Age of the parties is one aspect of capacity. In most states, parties to a contract must be 18 in order to form a legally binding contract. Some agreements must be placed in writing to be fully enforceable in court. A unilateral mistake occurs when only one party holds an innocent belief about the facts or law related to a contract. A mistake from failure to read a contract before signing is the most common example of a unilateral mistake of fact. When there is a mutual mistake, both parties have an incorrect belief about an important fact or the applicable law. Important facts that influence the parties' decisions about a contract are called material facts. Consideration is what a person demands and generally must receive in order to make her or his promise legally binding. There are 3 requirements of consideration. Each party must make a promise, perform an act, or forbear. Number 2, each party's promise, act, or forbearance must be in exchange for a return promise, act, or forbearance by the other party. Number 3, what each party exchanges must have legal value. That is, it must be worth something in the eyes of the law. For example, acts including binding promises, forbearances, detrimental changes in position, and property are all considered to have legal value. A person promising an action or forbearance is the promisor. The person to whom the promise is made is the promisee. In most contracts, the consideration necessary to legally bind a would-be promisor to his or her promise is identified through bargaining. One such action that the courts can take is to use the doctrine of promissory estoppel. When brought into use or invoked by the courts, promissory estoppel prevents promisors from stating in court that they did not receive consideration for their promises. For the courts to invoke promissory estoppel, the following conditions must be met. The promisor should reasonably foresee that the promisee will rely on the promise. The promisee does, in fact, act in reliance on the promise. The promisee would suffer a substantial economic loss if the promise is not enforced. Disaffirmance means a refusal to be bound by a previous legal commitment. Generally, a person lacking contractual capacity can disaffirm a contract for necessaries or goods or services that are not necessaries. In most states, if minors are unable to return exactly what was received under the contract, they can still get back everything they gave. This is true even if a minor returns used or damaged goods. In all states, minors cannot void any contracts approved for them by a court. For example, minors who are employed as actors or actresses or as professionals in sports usually have their contracts approved by a court. In all states, contracts to enlist in the armed services and contracts for educational loans cannot be disaffirmed. Also, marriage contracts of minors cannot be disaffirmed. In most states, minors are permitted to make deposits in banks and in savings and loan associations. Most states also permit minors to make withdrawals as if they were adults without any right to disaffirm these transactions. More than one-half of the states provide that minors who are over a certain age may not disaffirm certain contracts of insurance. In most states, minors who engage in a business or trade cannot disaffirm agreements involving their businesses. In some states, a minor who owns real property and sells it or borrows money against it cannot disaffirm until after achieving majority. In a few states, the lease of an apartment cannot be disaffirmed even if the apartment is not necessary. All states require that persons in certain occupations and businesses pass exams and receive a competency license to ensure that they can perform adequately. Persons engaged in trades such as barbers, plumbers, and electricians typically require a competency license. In contrast, if the license is a revenue license, whose purpose is only to raise revenue rather than to protect the public, contracts made by the unlicensed person are valid. Contractual rights may not be assigned if performance requirements would be materially changed as a consequence. Other situations in which may not be transferred include a right created under a contract that prohibits transfer of the contractual rights, claims for damages for personal injuries, claims against the United States, rights to personal services, especially those of skilled nature, assignments of future wages as limited by state statute. Various contract terms may affect performance. Conditions concurrent are the most likely terms to appear. These conditions are mutually dependent and to be performed at the same time. A condition precedent suspends the imposition of a contract's obligation unless an event doesn't occur within a set time or until the occurrence of a certain event. A condition subsequent in contract law specifies something that must happen or a contractual performance need no longer be required or enforceable. Finally, a condition negative specifies an event that must not happen to keep contractual obligations in force. In awarding consequential damages, the court again tries to place injured parties in the same financial position they would have been if the contract had been performed. Parties to a contract sometimes agree on a certain amount of monetary damages that will be paid if a particular contract breach occurs. These are termed liquidated damages. They are typically placed in a contract when an actual damage amount would be too speculative or too difficult to arrive in court. Failure to perform a duty under a contract is a legal wrong. Therefore, courts, even when no substantial harm has been done, will still award a token amount called nominal damages.